Welcome to the Deep Dive. Today we're wrestling with one of the most intellectually difficult questions in the entire legal system. How exactly do you put a fixed numerical dollar value on something as fluid and subjective as human suffering?
It's the ultimate legal paradox, isn't it? I mean, when a victim gets damages, it's easy to calculate medical bills, lost wages, those are concrete. But pain and suffering, that's trying to quantify, that which is immeasurable.
And that's right where the power struggle begins. You have the jury, which is supposed to represent the community, deciding the value. But what happens when that value just seems criminally low? Or, on the flip side, outrageously high? We are diving deep into that exact legal line a judge has to cross before they can interfere with what a jury decides. We're talking about things like additor, which is what happened in our main case today.
Right, additor to increase an award or remediator to reduce one. And our mission here is to really dissect this high standard of judicial restraint. We have to establish why the law insists on deferring to the jury. And we're going to use our key source, the fantastic case of Ortega v. Belony, to find out exactly where the legal definition of unreasonable really begins.
Yeah, we're going to find out why a trial judge's personal feeling, even profound shock, is simply not enough legally to override what the jury decided. So let's start there. At the root of this deference, why can't a judge just step in and correct what seems like just a manifest wrong?
Well, the prohibition is really rooted deep in common law and in the constitutional right to a jury trial. The job of assessing pain and suffering is, and this is a quote, uniquely reserved to a jury. It's not just because it's intangible. It's because it represents the community's collective wisdom. So the core test, which was established a long time ago, is whether the verdict is one a jury of reasonable persons could have returned.
That's a huge level of deference. So the moment a judge sees a low award and thinks, wow, I would have given them 10 times that, they're legally required to just stop.
Exactly. They cannot, and this is the key policy phrase you have to remember, they cannot sit as a seventh juror. The judge is forbidden from substituting their own personal judgment, their own empathy, for the jury's collective decision.
So if the judge can't use their own feelings, they have to apply a very strict, mandatory legal checklist. What are those two high-bar standards that have to be met before a judge can legally overturn a damage award?
Right, there are two, and the record has to establish one of them. We can think of them as two conceptual tests. Test one is what I call the influence test. Was the jury improper? Specifically, was the jury influenced by prejudice or passion or even corruption? And you need objective evidence for that, not just a hunch.
Okay, so that's the first one. What's the second?
Test two is the reasonableness test. Is the award so inadequate or so excessive that no reasonable jury could possibly have reached it based only on the evidence that was presented? If one of those tests is met, the judge can step in. If neither is met, the judge's hands are tied. They have to uphold the verdict.
That clarifies the doctrine beautifully. Let's now use those two tests to do a really rigorous analysis of the case that puts all this under a microscope. Ortega v. Belony.
It's a perfect case for this because the trial judge was absolutely 100% convinced that a great injustice had just happened in his courtroom.
Okay. Let's analyze Ortega v. Belony. First, what are the legally dispositive facts about Blanchard Belony's injury and his recovery? What made the initial injury so dramatic?
The initial injury was severe. Belony suffered a broken neck in a car accident. He was in the hospital for over a week, and critically, he had to wear a stabilizing halo brace. This thing was bolted into his skull for 3 months. During that time, he needed a lot of help with just basic daily functions. It's a very, very visceral injury.
Sounds just devastating. But what were the mitigating facts? The facts that the defense and then later the appellate court really zeroed in on?
There are a couple of big ones. First, he repeatedly declined to have surgery. Second, the medical testimony confirmed that his injury had substantially healed not long after the halo came off. But most importantly, his own testimony at trial was key. He said he hadn't sought treatment in over a year, he felt almost normal, and he had, quote, no difficulty performing the activities of daily living.
So he basically told the jury he was doing pretty well.
He did.
And what was the verdict, and what did the judge do about it?
Well, the jury found him 70% negligent. They awarded him his full medical expenses, which is around $33,000. But for pain and suffering, they initially awarded zero. The judge sent them back to reconsider, and they came back with $5,000 for past and future pain and suffering. The trial judge, he reacted furiously. He said he was shocked, and he actually called the jury cold-blooded. Then he granted additor and unilaterally raised that $5,000 to $250,000.
Okay, a 50-fold jump. That is a massive increase. So given that, what was the precise legal issue that went up to the appellate court?
The issue is pretty narrow. Did the trial court make a mistake by granting additor based only on the judge's subjective feeling that the $5,000 award shocked the conscience? Especially when the evidence from the plaintiff's own mouth could support a finding that his residual pain was minimal.
So what rule of law did the appellate court apply to decide if that $5,000 verdict was valid? Can you state the rule and break it down into those two testable elements we just talked about?
Absolutely. The court applied the binding standard from a case called Griffiths v. Hill. It says a damage verdict can only be disturbed if it meets one of two conditions. The first element: it was induced by improper influence, think prejudice, passion, or corruption. The second element: it's so legally inadequate that a jury of reasonable people looking at the evidence could not have possibly returned it. These are the two hoops the trial judge had to jump through.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the appellate court apply that first element, the influence test? Did the judge's own shock count as the objective evidence needed to prove passion or prejudice?
No, not at all. It absolutely did not. The appellate court found, quote, no basis whatsoever in the official record to think the jury was improperly influenced. The judge's personal emotion, his horror at the low number, that's not evidence of jury corruption, it's just his opinion. And by acting on it, he was doing the very thing the seventh juror rule prohibits. So since there was no real evidence of impropriety, the court said the first element fails.
That makes the line crystal clear. The judge's empathy is irrelevant. Only hard evidence of misconduct matters.
Got it. Now, what about the second element, the objective reasonableness test? Could a jury of reasonable people have genuinely returned a $5,000 award, even though the plaintiff broke his neck and had to wear a halo?
This is where the analysis gets really interesting. This element hinges entirely on the facts of the recovery, not the facts of the initial injury. The court looked at Belony's condition at the time of the trial. They pointed directly to his own statements, that he felt almost normal, that he'd returned to his daily life, as clear evidence that a jury could reasonably assess his future need as minimal.
So the jury was allowed to just believe the plaintiff when he testified about how resilient and recovered he was. Precisely. They were entitled to assess his credibility. Maybe they saw him as a stoic plaintiff who was minimizing his own pain, and because of that, they were justified in weighing his total residual suffering as being low. The evidence showed quick healing, no need for future treatment, high functionality. So the court said $5,000 was not unreasonable. It was low, sure, but it wasn't so low that it completely contradicted the facts in the record. The second element failed, too.
And after analyzing both of those elements, what was the court's final binding conclusion?
The appellate court reversed the trial court's order of additor, and they reinstated the jury's original $5,000 verdict for pain and suffering. The judge had committed reversible error, he had substituted his own judgment for the jury's, and he failed to clear that very high bar of either the influence test or the reasonableness test.
That reversal is such a powerful defense of the jury system. But let's really test the limits of this doctrine. Ortega feels like a close call because the plaintiff recovered so well. Let's use a visceral hypothetical to find the boundary line where a judge must step in.
Right, we need to find where $5,000 crosses the line from just low but reasonable to legally inadequate.
Exactly. So consider this. A jury awards $5,000 for pain and suffering. But the undisputed medical facts show the plaintiff suffered a catastrophic spinal injury, permanent quadriplegia. They require 247 care for the rest of their life. Would the Ortega precedent, which protected the jury because the plaintiff was almost normal, force an appellate court to uphold that $5,000 verdict?
No, not a chance. That verdict would be overturned immediately, unequivocally. It would fail the reasonableness test catastrophically. The entire logic in Ortega depends on the factual record supporting minimal future need. In a case of permanent quadriplegia, the evidence of suffering, of loss of enjoyment of life, of lifelong dependency, it's just insurmountable.
So no reasonable jury could logically connect the proven facts of lifelong catastrophic pain with only $5,000 in compensation.
That's the whole point. An injury that's severe renders a $5,000 award legally inadequate as a matter of law. Judicial interference in that hypothetical would be mandatory. The judge would be required to intervene. The Ortega case simply shows us that where the recovery is strong, the jury's low valuation, however surprising, has to stand.
This entire analysis provides such a structured way to approach this issue. It really forces you to suppress your emotional reaction and just stick to those two objective legal questions.
That is precisely the takeaway. And for you, the listener, when you're facing a problem involving judicial review of a jury's damages award, here is the required sequence to follow. It synthesizes all the rules from this deep dive into an actionable checklist.
This is the practical framework we need.
First, identify the damages type. You see pain and suffering, you should immediately think, okay, this triggers the highest standard of judicial deference.
Start with deference. Got it.
Second, state the presumption. Always begin your analysis with that core doctrine. The verdict is clothed with the presumption of regularity, and the judge cannot act as the seventh juror. Third, test one, the influence check. Look for objective evidence. Did the judge point to something real, like jury corruption, or did the judge just say they were shocked? If it's only a subjective feeling, that test fails. You move on. Fourth, test two, the objective reasonableness check. Could a reasonable jury have reached this number based on the facts? And this is where you synthesize the evidence about the plaintiff's condition at the time of trial. Was the recovery quick, or was the injury permanent and catastrophic? Was the plaintiff almost normal, like Belony, or do they need expensive, lifelong care?
And then the final step.
And finally, your conclusion. Only if the verdict fails, test one or test two, meaning the award is just completely inconsistent with the undeniable facts, should the judge intervene. If the judge just substituted their own empathy for that legal standard, any order for additor or remittitor has to be overturned.
This has been a fascinating look into that tension between justice and due process. We've learned the law demands enormous judicial restraint. The jury's assessment of a plaintiff's credibility and their actual recovery is paramount, even when an award feels just shockingly inadequate. The facts about Blanchard Belony's recovery were ultimately more important than the severity of his initial broken neck.
Indeed. The system fiercely protects the jury's right to decide that value. But that brings us back to the central policy question this ruling creates for you, the listener. If the law so strongly validates a jury's decision that a stoic plaintiff who feels almost normal deserves only minimal compensation, does that protection unintentionally incentivize plaintiffs in future trials to, perhaps, exaggerate their residual pain?
To avoid being classified as resilient and risk having their suffering valued at $5,000, it shows how the legal definition of reasonable compensation can actually shape human behavior in the courtroom.
Exactly. The line between being stoic and being compensated is a very fine one indeed.